Welcome to this video. Here we will be talking about handling of claims, managing demands under a guarantee. This is crucial because claims are very important. They trigger the payment or they make it possible to get the payment, or sometimes because the way the claim is presented, payments may not be coming through. There could be challenges during the claims process. We will try to understand how to prepare and process a claim or a demand under the guarantee from the beneficiary's angle to ensure timely and accurate payments. Guarantees are instruments that foster trust and efficiency for an underlying contract. For the guarantees to remain trustworthy and a reliable and independent instrument, the handling of the claims is very important. Ensuring claims are compliant is accordingly very much necessary. A claim or a demand is a formal request made by the beneficiary to the issuing institution for payment under the guarantee. Claim is a mechanism through which the guarantee fulfills its purpose. Demand is what the result is for the security and assurance that the beneficiary wanted. What are the key aspects of a claim? Triggering payment. A compliant demand triggers the issuing institution or the bank their obligation to pay the guaranteed amount to the beneficiary. In case of independent guarantee and in case of URDG subjected guarantees, payment is contingent upon submission of a compliant document. There could be no dispute over the underlying contract. There is a need for documentation in the form of a demand, a written demand or a claim. It must include all required documents, which could be a statement that the counterparty defaulted or the underlying contract has been breached. Missing document, incorrect document, incomplete document can lead to rejection of the claim. And so, the payment and the guarantee, the compensation, may get denied or delayed. There should be written notice of default. There needs to be normally no proof of non-performance. And normally, the submission of the original guarantee is also many times not mandatory. The claims are processed in time. Within 5 to 7 working days, the bank will go back saying the claim is compliant and we are honoring, or the claim is not compliant and so we refuse to honor your claim. The issuing bank are obligated to promptly respond. Now, this timely response is what makes the guarantee or the guarantor reliable, and the trustworthiness of the guarantee comes from this professional handling of the claims. What are the common problems that one faces with a claim? One is non-compliant demand, missing documents. Beneficiary fails to include the required documents. Incorrect documents. A document submitted need not meet the guarantee's specification. Sometimes it is not dated, sometimes it is not signed, sometimes it is stale, sometimes it is incomplete or incorrect. Then comes the format errors, minor discrepancy like spelling mistakes can also lead to rejection of the claim. What is the impact? If the claim is rejected, then no payment is due. What happens? You will have to present a new claim, which means there is a delay in getting yourself compensated. Then there is an increased administrative burden because you have to resubmit all the documents or reprocess the claim. And then what happens is the potential dispute between the beneficiary and the issuer when multiple claims are subsequently rejected. This happens because of the interpretation of the terms, not having proper understanding of the local legal framework or the requirements under URDG could cause this confusion. Ambiguities in the language, different understanding, different interpretation, different meanings. So, use of uniform framework as much as possible will minimize these problems. Sometimes the dispute may lead to litigation. It will have its own costs and delays. Arbitration clause, if it is not there, it is still more problematic. So accordingly, all this will cause time overrun and cost overrun. So use of standardized framework, clear definition of the terms and conditions, including dispute resolution mechanisms, will help in preventing escalation of delays or disputes. What are the steps that one should take is to review the terms and conditions of the guarantee, prepare the documents well in time or arrange for the completeness, accuracy and compliance of the specified evidences, and then submit them within the expiry period of the guarantee. If unsure, seek clarification from the issuer as to how a claim has to be submitted at the time of collecting the guarantee itself. When a claim is presented, track for its progress and address the issues, if any, promptly. So, this communication and clarity will ensure that the guarantee will serve its purpose on a rainy day. If a corporation's claim lacks a signed notice of default, it would lead to rejection. So, if there is a default, then there should be a declaration that a default happened. So, signatures are essential on claims. Normally, it should be dated to ensure it is presented within the expiry date of the guarantee. If the corporate argues that the missing signature is minor, this highlights a need for clear terms. So, the guarantee should have said ink signed or wet signed, etc. Resubmitting the signed notice resolves the issue in the normal case, but it should happen within the expiry date of the guarantee, because any number of claims can be submitted. So, what the parties should do: prepare or gather all the documents well in advance, double check for completeness and correctness, submit within the validity period, ensure that it is properly signed and dated, ensure the formatting is complete and correct and consistent. Non-compliance with these may lead to denial of a payment or a delay in the payment. If the claims are compliant, the issuing bank will normally pay promptly. So, the issuing bank processes a compliant claim. They will disburse the guaranteed amount. Compliance is the key. Parties should learn that the importance of adhering to the terms and conditions of the guarantee and interpreting as per the URDG and following the local law is of utmost importance, because the claim process is the proof of the pudding. Learning from disputes is very costly, but learning is very important to avoid future complications and disruptions in the claim process. Thanks for watching this video. Let us meet again in another session.